Dear participants, we continue the program of the second day of the UAA Annual Arbitration Conference, and we move on to the session number 3 about court assistance in taking of evidence in support of arbitration. This session would be moderated by Alexander Druk, board member of the Ukrainian Arbitration Association and partner at Sayenka Harenka, Kyiv, Ukraine. Colleagues, the floor is yours.
Welcome. Welcome everyone to the second day of the Ukrainian Arbitration Association Annual Arbitration Conference. I am pleased to start this first session of the day and third session overall. It is dedicated to a very interesting topic. It is court assistance in taking of evidence in support of arbitration. We have a great and exciting lineup of speakers for today, representing 4 different jurisdictions: United States of America, Ukraine, UK, and Switzerland. Let me briefly introduce each of the speakers. So first, Remy Gerber. He is a partner at the US law firm Moller Lamken. He is an international arbitration lawyer whose practice focuses on cross-border commercial disputes, international investment disputes, as well as related litigation. He is trained in the UK, US, France, and Switzerland. He represents clients across various sectors, and he has experience in ICC, LCA, UNCITRAL, Swiss Chambers, DIAC, ICSID arbitration. Remy holds a permanent academic appointment in the University of London, Queen Mary, where he is a director of an LLM program in arbitration. He is also former deputy registrar of the LCA and the author of the leading treatise on the LCA arbitration and arbitration institutions. Our next speaker is Irina Moroz. She is a partner at the Ukrainian law firm AGA Partners. She is a recognized expert in the field of international arbitration, international trade, and litigation. She is a member of the Chartered Institute of Arbitrators and a deputy head of the International Arbitration Committee of the Ukrainian Advocates Association. Irina has extensive experience in dispute resolution, including handling of complex commercial arbitrations and resolution of trade and maritime disputes. Irina has wide experience of recognition and enforcement of arbitral awards in different jurisdictions, including Turkey, Switzerland, Hong Kong, Russian Federation, Georgia, Egypt, and others. Going to United Kingdom, we have Tatiana Nesterchuk. She is a barrister from Fountain Court Chambers. She has been practicing as a barrister in England and Wales for over 15 years. She regularly appears as an advocate in arbitrations and the English courts, in all instances from the High Court to the Supreme Court. She also has extensive experience in sitting as arbitrator, so she knows the rules of the arbitration games both from the trenches and as an arbitrator. Her expertise in general commercial arbitration litigation with a special focus on fraud and asset recovery. And from Switzerland, we have Gabrielle Natter-Bass. She is a partner at the Swiss law firm Hamburger in Zurich. With over 20 years of experience, Gabrielle has acted as party counsel, arbitrator in numerous international commercial arbitration proceedings, ad hoc and institutional. She also regularly represents clients in investment treaty arbitrations and complex cross-border litigations. Gabrielle served as president of the arbitration court of the Swiss Chamber Arbitration Institution, SCAI, from 2016 to 2020. She is a board member of the Swiss Arbitration Association, ASA, member of the LCA Court, and the co-chair of the ICA ASIL Task Force on Damages International Arbitration. Gabrielle also received the Client Choice Award 2020 in Switzerland in the category Arbitration ADR. So in order to make today's sessions more interactive and interesting, we decided to prepare a case study and run it across 4 different jurisdictions to see how it will play out. So the case is quite simple. There is a pending commercial arbitration between 2 parties, a seller and a buyer, under an M&A transaction. The seat of arbitration is in Ukraine, and there are uncooperative witnesses in all of 4 jurisdictions: the US, Switzerland, UK, and Ukraine. And there are also documents which might be relevant to the case material, to its outcome, also held by one of the parties or a third party in the US, Switzerland, the UK, and Ukraine. And before we discuss and go on with each of the jurisdictions and potential measures in support that could be obtained in different courts, we would like to run a poll with the audience and ask the audience the question: do you find that court assistance in taking of evidence in support of arbitration is useful? So please use the QR code and vote. We will give a minute and a half for this process to be completed, and we'll then proceed with our discussion. Okay, we have a live updates to the voting results. We will wait just a bit to maybe gather some additional votes, but preliminarily we see that we have more votes for yes, that audience thinks that it is indeed useful, than no. We will try to run the same poll at the end and see whether there is any difference in the opinion from the audience. So thank you. I think we can switch on to the discussion. And we start first with United States. And the first question is to Remy. Is it generally possible to even obtain this support from courts in your jurisdiction in support of commercial arbitration?
Well, Alexander, if we take the specific case study that you've described a minute ago, which is really a commercial arbitration between two parties, you described an post-M&A dispute, the short answer is in America, it depends. It depends on what courts you're going to approach, which jurisdiction within the US you're going. I think a lot of us will know, there is a provision under U.S. law. It's called Section 1782. It's Title 28 USC Section 1782, which allows a U.S. court to order a party that's residing within the court's jurisdiction to provide discovery for use in proceeding before a foreign or international tribunal. And so that's a very powerful tool which allows parties, litigants outside of the US to try to leverage the very broad discovery system of the US courts in support of foreign court proceedings, for example, but also in support of investment treaty arbitrations. Right now, there is a measure of uncertainty in the US as to whether or not that Section 1782 should be available in support of private commercial arbitrations. And so that's why I said it depends. There are certain circuits, so certain federal courts in America, which have found that Section 1782 can be relied upon by foreign litigants in support of a private commercial arbitration like the one that you just described. But there's other circuits, so other district courts and appellate courts in the US that have found that Section 1782 should not be available in support of private commercial arbitrations. The reason for the split is really because of the wording of that provision of US law, Section 1782. It relates, as I said, to discovery in support of a foreign or international tribunal. And so some have argued that foreign tribunal or international tribunal does not cover a purely private commercial arbitration. So there's a split at the moment. The good news is that the split is likely going to be resolved before the end of the year because the US Supreme Court has accepted to look at this issue in a case called Servotronics against Rolls-Royce. The case is pending before the US Supreme Court. It's been partially briefed, and I understand that we should expect a decision probably by the fall or by the end of this year. And so we'll know for sure whether or not 1782 is available to support a private commercial arbitration. But really the short answer to your question is we do have in the US a specific provision that, theoretically speaking at least, allows foreign litigants to come to the US and ask the US courts to force a party to either provide documents or testify in support of court proceedings that are taking place outside of the US. And so it's a very powerful tool, in theory at least. And as somebody who originally comes from a civil law jurisdiction, albeit I've been practicing in common law jurisdictions for 15 years, it's really something that's on paper very attractive if you're litigating outside of the US, especially in Europe, in Eastern Europe, in the former CIS region, etc.
So as I understand, Remy, there were successful cases where the parties were in position to actually get the support.
That's correct. Yes, there's been a number of cases in the US, and it's quite common to make a 1782 application. It's something that firms often are asked to help with. My firm has certainly been involved in a number of 1782 applications. So it's not something that's just on the books. It's a provision of US law that is actually applied in practice very regularly, with the caveat that I gave you, Alexander, which is that at the moment, there is a split between different federal courts in the US as to whether or not you can use this for commercial arbitration. But yes, it's not just on the books, it's being used all the time.
So going to the next jurisdiction, UK. Tatiana, could you let us know what kind of support, evidentiary support, could be sought from the courts in UK?
Okay, so very quickly, UK courts are able to offer the parties support, although they do operate under the general principle of non-intervention. The kind of support that they can offer is, there are only two sections of the Arbitration Act which you need to be aware of. That's section 43 and 44. Under section 43, they're slightly different. The court can secure attendance of witnesses to give evidence or to produce documents. And under section 44, the court can help with the taking of the evidence and with the preservation of documents. There is no general power of ordering disclosure. So that's probably it in the nutshell. Both sections are subject to conditions, slightly different, but both sections have the same basic condition, which is that there must be either a permission of the tribunal to make the application to court or the agreement of the parties to the arbitration. So that's the basic condition. That's probably it from the UK's perspective.
Thank you. And this leads me actually to another question about who can actually apply to the court. So is it the tribunal itself? Is it a party? And should some preliminary agreement from tribunal be sought? And Gabrielle, could you comment on that from Swiss perspective?
Yes, thank you, Alexander. Let me first tell you that Swiss state court assistance was always available. We had, however, a big distinction the way you had to proceed when it came to Swiss seated arbitrations and arbitrations with a seat abroad. Swiss seated arbitration, there already before, arbitral tribunal and parties could apply directly to state court. Before the beginning of this year, however, such a possibility was not available, and if a foreign seated arbitration wanted to get access to Swiss courts for assistance in evidential proceedings, they had to go over the judicial assistance proceedings, very burdensome, the Hague Convention on the taking of evidence, or bilateral agreements. Now, as the beginning of this year, a new article was introduced in the Swiss International Private Law Act, which now allows also for arbitration proceedings seated abroad to directly access Swiss state courts. So who can do that? It is either the arbitral tribunal, who could apply directly to the court at the place where the taking of evidence should take place, or a party. If, however, a party is trying to resort directly to the state court, it needs the approval from the arbitral tribunal. This also from a practical perspective, because in many arbitrations, if they would do so without the approval of the tribunal, there's quite a risk that the tribunal would not allow the evidence so retracted to be introduced in the arbitration proceedings. So this is more or less an answer to your question, Alexander.
Thank you. So, and is it maybe different in any other jurisdiction? Whether it's the same approach that the standard the default rule is that it is the tribunal who can do this, and the other rule is that a party, but with tribunal permission.
So in the US, the position is interesting. It's any interested person is permitted to submit an application under Section 1782 for discovery. And so what it means is, first of all, it doesn't have to come from the arbitral tribunal itself. In fact, it would be incredibly rare for an arbitral tribunal to be the applicant, the petitioner. Second, a party doesn't even need the permission or the authorization of the arbitral tribunal before making an application. So any interested person can make an application. And so, of course, the parties to an existing or forthcoming international arbitration would likely be interested person, but there's also the possibility that a non-party to an arbitration who's nonetheless interested could potentially seek discovery under Section 1782.
I mean, Remy, you are totally right. This is the same here, but just let me precise, and I think that problem exists all over the world, Alexander. If you would, without the approval of the tribunal, go and solicit evidence and you try to introduce it in the arbitration, it may not be admitted. And I was, in fact, also once a party counsel in an arbitration where exactly opposing party has done so, and the tribunal has then not admitted that evidence, also saying clearly it was a circumvention of the procedural orders they have taken in place and put in place with regard to evidentiary proceedings. But it's an interesting question, and there is also one interesting decision from the Swiss Federal Supreme Court, who has actually supported an arbitral tribunal not allowing to let such evidence to be introduced, because it says at the end of the day, it's not a blatant violation of a right to be heard if the tribunal had good reasons for not allowing a party to solicit in such a way evidence and try to introduce it to arbitration, which otherwise would not have been available to such party in the jurisdiction where the tribunal was seated.
So just quickly adding, in the UK, it's only the party to the arbitration who has the right to make the application to the court to ask the court's assistance. So, and in very limited circumstances, generally, depending what you're asking for. If you're asking for to secure an attendance of a witness at a hearing, then it doesn't matter where the arbitration is seated, but the witness must be located here in the UK if you're asking the English courts for assistance, and it's in respect of proceedings also conducted here in the UK. It's just the logistics. So yeah, it's only the party who can do it. Certainly not under the Act. The Act doesn't permit the tribunal or the third parties to do the applications.
Thank you, Tatiana. And then a question to Irina. Is it possible to apply in Ukraine to the court for such measures? And if yes, is it possible to do it after commencement of arbitration or even before?
In the meantime, Alexander, so in the US, you can, what's very attractive is you can make your Section 1782 application even if your proceedings have not yet been commenced, and even if they're not even imminent. It's possible to make a Section 1782 application as long as you can demonstrate that proceedings are reasonably contemplated. So, for example, in an arbitration, if you send a notice of disputes before you actually filed your request for arbitration or notice of arbitration, you could probably do your discovery request before the arbitration starts.
And do you have to give to the court some undertaking that you will commence arbitration within like a couple of months or something like that?
So I'm not sure that you have to give the equivalent of a solicitor's undertaking.
Okay. Irina, what is your position? What is the position in Ukrainian law?
Thank you. Do you hear me now?
Yes.
Yeah, great. So basically, my answer is closely related to the previous question: who has the right to make such application? And basically, Ukrainian law is designed in a way that it is possible to make our application and to seek assistance from the court only after commencement of the arbitration, because such application can be made either by the arbitral tribunal directly or by the parties with the consent of the tribunal. So in order to make such application, definitely you should prove that you have ongoing arbitration that is seated in Ukraine or otherwise abroad. Ukrainian law allows to make such application in support of Ukrainian seated arbitration as well as arbitrations that are seated abroad. The problem with our legislation is that we do not have a specific and detailed procedure regarding the form of this application. And that's why in practice it raises numerous questions, because Ukrainian court is very formal and Ukrainian courts are not very well informed about the different arbitration institutions abroad. Of course, when they will receive a certain inquiry or application from foreign tribunal, first of all, they should be persuaded that this tribunal exists, that there are certain arbitration rules, and that Ukrainian court has power to assist this particular tribunal. That's why our recommendation would be to make such application as detailed as possible, describing the name of the parties, the essence and the substance of the disputes, to provide maybe arbitration clause and arbitration agreement and maybe certain arbitration rules, in order to give the necessary basis for Ukrainian court to accept application and then to proceed with its consideration.
So, Irina, then would it not be better for a party to actually make application, because a party could explain all these details? And I see quite potential problems with tribunal being represented somehow before Ukrainian court.
Yes, you are quite right, because we have issues regarding representation. In order to make any application to Ukrainian courts, the first step is to prove that you are authorized. And you should have power of attorney or specific agreement and engage advocate in order to represent you. So, of course, in practice, I see that it will be quite complicated for the tribunal to make direct application. So, most probably it will work if application will be made by the parties and the party will provide a confirmation that tribunal gave consent to such application, because it will be easier in terms of proving representation and in terms of putting all necessary documents to the court and supporting such application.
And in terms of basically the forms of support, is it the same as another jurisdiction? So it's possible to question a witness and request production of documents, right?
Yes, you are quite right. In Ukraine, we can request disclosure of documents, preservation of evidence, witness examination, and examination of evidence at the place of their location. And we have a strictly defined jurisdiction. So basically, the competent court will be the court of appeal at the place of location of evidence or at the place of residence of witness.
Thank you. So now going back to our case study and what we discussed at the start, we have these 4 uncooperative witnesses in each of the jurisdictions. And let's try to explore what is actually possible to do in respect of getting some evidence from these witnesses. So my next question is to Gabriel. So can this uncooperative witness in Switzerland be subpoenaed to appear before the court and give evidence? And how this process takes place? Is basically this witness takes oaths? Is it potentially liable to criminal punishment for perjury?
Thank you, Alexander. Just one thing to add to Irina was interesting to listening to you, and I must say you have a lot of parallels to Switzerland. Also in Switzerland, the arbitration needs to be pending for the very simple reason that you have to show a necessity for the state court to assist. And coming to your question, Alexander, if a Swiss court is approached, it applies in general its own law. And interesting, only as of this year, the provisions now introduced in the Swiss International Private Law Act also leaves open the possibilities for new forms to be applied. And as you can assume, I mean, this is now a couple of months and we have no case law, so it's going to be interesting to see. That's important when I give you answers, because my answers I have drawn from what I think will be the practice and how it is handled in analogiam to what we have seen if a state court was approached with Swiss arbitration seated arbitration was in Switzerland. So now coming to your question. Here it becomes a bit technical because we in Swiss state court proceedings, we make the distinction between a witness, which is a third party witness, and a party representative who would be summoned. And when it comes now to arbitration proceedings, both parties are deemed to have an obligation to appear in front of the court. But the court takes the view that if a party would not appear, then it is for the tribunal to draw the consequences, negative interferences, and it would simply state this party has not appeared. Whether when it comes to a third party, then the court would apply coercive measures such as invitation, subpoenas, invitations, and would force that party to appear. So we have these interesting distinctions whether it is a party or whether it's a third party witness, which in my view makes practical sense because it is then truly for the arbitral tribunal to decide. And also, let's face it, from a practical point of view, the party will in all likelihood have to appear in front of the tribunal. So in practical, you will not see that. But if a party is then appearing in front of the court, then, Alexander, they are both admonished to tell the truth. And they will both be admonished that if they would not tell the truth, they could be criminally sanctioned. And that is in fact possible. And for both, whether for a party or third party witness, criminal sanctions could be imposed. Taking an oath is not common in Swiss civil procedures. And as such, with this possibility to actually admonish them and threaten them with punishment, it is also not necessary. So you would not see witnesses taking an oath. This is not familiar in Swiss civil proceedings and would not be taken place and is not allowed.
Thank you. And now getting a bit even more technical into actual process. What happens when this witness comes to the court? Question to Tatiana. So what procedure in examination of witness should the court follow? Will the judge put questions to a witness, or are the parties or maybe even the arbitrators allowed to also attend this hearing, take part in this examination and also put questions?
The way the procedure works in England is that the only thing that the court will do, it will summon the witness under Section 43, or it will require the witness to give evidence by means of a deposition under Section 44. And so, the only thing the court will do is issue the order requiring the witness to come and give evidence. That is it. So that's the role of the court. The court will not be asking any questions. When the court issues summons, it has to be in relation to a witness located in the UK and also in respect of proceedings in the UK. So what happens when the seat of the arbitration is outside the UK is normally a hearing is set up, in any building, in any room. It could be in barristers' chambers, it couldn't be in the ICC court, for example. A hearing room will be set up, and usually where the arbitration is seated somewhere else and it might not be convenient for arbitrators to travel to another jurisdiction, to the UK, there'll be a video link, for example. And it might be, and somebody will be at the hearing, in order to take an oath for the witness and to help the witness. And the questions would generally be asked by an advocate. So the party who wants to call the witness will be asking questions of the witness, and then the other side, well, it really depends on what the procedure is at the seat of the arbitration. I mean, if this was in England, then the other side would be entitled to cross-examine, and of course the arbitral tribunal would be entitled to ask questions. So that's the hearing. If we're talking about a deposition, that is again a procedure which will be set up anywhere, really. It could be in lawyer's office, and both parties will be entitled to take evidence, and a note of that deposition will then be taken and presented to the tribunal. So those are the two different procedures that could be used.
So in terms of a court hearing, the court more or less performs some administrative function, just asking the witness to appear, and more or less then it's the same as at any other arbitration hearing.
Absolutely, that's exactly right. The court, there will not be a court hearing in terms of listening to the witness. The court will simply grant the order or not grant the order, issuing the summons, and so you will have that sanction. So if the witness doesn't appear, there will be that sanction of the court, the criminal sanction, that if you are disobeying the order of the court, you're in contempt of court. So that's one of the advantages of going to court. If you have a reluctant witness, I think you have to be very, very reluctant and very brave to disobey the order of an English court.
Thank you. And is it any different in maybe other jurisdictions?
Yeah, I was just about to comment. I was just about to comment. It's really interesting to hear the journal, because in Switzerland it's totally different. We have a very strict system. In ordinary Swiss court proceedings, you're not allowed to approach a witness. So you're not even allowed to prepare a witness or inform the witness what they would be supposed to testify. You simply offer the witness. And so when the state court is actually asked to provide assistance to arbitration proceedings, they are totally unfamiliar with the usual practice how arbitration proceedings are conducted. And that's why, in all likelihood, what I have seen before, very limited, even for Swiss-seated arbitration, is that the court will, of course, ask for a list of questions. And as it is normal in Swiss civil proceedings, it is the judge who will simply ask these questions, then they are minuted, and this record is done. Now, however, it's going to be interesting with this newly introduced article, and I think we will see judges who may apply more flexibility and use their discretion that they have now, and may even allow, in fact, that additional questions are spontaneously asked by parties or even a tribunal, and we may come also to the topic, may even allow, for cross-examinations or other forms which are totally unknown in ordinary Swiss state court proceedings. So basically, contrary to you, Tatjana, you have the typical Swiss courtroom and the rules that apply in a Swiss courtroom that will dictate this assistance proceedings.
Yeah,
I'm Irina, is it probably the same in Ukraine? Is it a civil law country?
Yes, basically Ukraine has very similar position to Switzerland. So basically you should expect to have like a formal hearing, because of course our judges are not familiar with the International Arbitration Institution, and don't be surprised if they will ask at the beginning what is LCAA and what is ICC, and you should explain that these are arbitration institutions seated in that or this country and so on. So you should be prepared that it will be like a formal hearing, and the court will be guided by the general rules concerning witness examination. So, of course, at the beginning, the court will inform the witness that they might be contempt and they might be a criminal responsibility in case they will give false or untruth statements. And the court will ask the questions that were prepared by arbitral institution or arbitral tribunal. There should be a list of questions prepared. So the court will not put the question on its own. And our civil procedural code provides that the parties to the arbitration proceedings have right to be present during the hearing and to put questions as well. Interesting thing that our code does not provide that arbitrators or representatives or arbitration institution have right to be present. So this issue is silent, and most probably the judge will only ask the questions that were put in a written form by arbitral tribunal or by the party, and the parties that will attend the hearing will be allowed to ask the questions as well.
Thank you. And Remy, what is the approach in the US? Is there some kind of list of questions, or is the system similar to UK? And if yes, what are the regular rules for examination of witness?
Sure. So I think the system under section, the process under section 1782. So again, with respect to seeking discovery in support of foreign proceedings, is not very different from what Tetiana has described with respect to England and Wales, in the sense that the testimony of the witnesses would be taken in the form of depositions. Questions would be asked by the petitioner's attorneys directly to the witness in the absence of a judge, not be taking place inside a courtroom. The judge would not be asking questions. There would typically be a court reporter who would first administer an oath for the witness and then take a verbatim transcript of the testimony, which could last multiple hours if you want. And so the short answer, you asked about the rules. Typically, the rules that would be applied would be the federal rules of civil procedure, which are the traditional rules applied in a federal court litigation, if you want, in the US. So there would be no hearing. It would be really deposition. An interesting thing also to note is that because you don't have a judge present during the deposition, the attorneys don't have as many opportunities to object to a certain line of questioning as they would do in the US courts, where the rules of evidence would apply and they'd be able to raise objections to questions. The only sort of objections that you typically raise would be about privilege, if a question would force somebody to breach an attorney-client privilege. But otherwise, there's much leeway for the questioning attorney.
So as I understand that at the end you have this deposition in form of this minutes prepared by the court reporter, and this is the document that the party can potentially use in arbitration proceedings.
That's correct, but it could also be video recorded in some instances. So you could also have a video potentially of the deposition. It's quite common.
Mm-hmm. Thank you. And then question to Irina again. In the Ukrainian proceedings, in civil law proceedings, what is the outcome of this whole examination of witness? Does the judge prepare some document or maybe ruling? What happens next, and who receives the result of this examination?
Generally, it's a very interesting question because Ukrainian law is silent on the form of document that should be prepared based on the outcome of witness examination, as well as the law is silent where to send this document and who is entitled to receive this document. So my view is that Ukrainian court will simply be guided by the general provisions of the hearings and will prepare minutes depending on the outcome of examination that will contain the general course of the examination. And I think that the court will be guided by Article 250 of Civil Procedural Code of Ukraine that obliges the court to execute minutes concerning the separate court actions that were made beyond the court hearing. And of course, such minutes should include the names of the parties, their details, the general descriptions of the questions that were asked and the answers that were made. Of course, the problem might be that such minutes sometimes are very general. So it is not efficient, and sometimes it is very unhelpful because you cannot get into the details of the answer of the witness. Mm-hmm. And in such situation, it might be helpful to have audio recording. Under the general rule, all court hearing should be made with the audio recording, and the parties have right to ask the court to provide them with a copy of audio recording. So it will be advisable for the parties after completion of the hearing and before even the hearing to persuade themselves that the court is arranging audio recording. After completion of the hearing, request the copy of this audio recording from the court and to receive the minutes of the hearing concerning the witness examination. Of course, court hearings are not similar to arbitrations, for instance, where you can have a private transcriptors that will put in the details word by word everything that was said. In Ukraine, it is basically impossible. From my experience, I have never seen such a request to be made. So if you make such application, you should take into account that most probably, even if you will ask the court to make your own personal transcript, Ukrainian court might reject. Otherwise, please be sure that Ukrainian court will make audio recording and you have a right to ask this audio recording from the court. Concerning the
So I
persons...
assume that so I assume that you can just take this audio recording afterwards and make your own transcript.
Yes. So that might be the way out from this situation. And of course, under the default rules, the parties that participated in the hearing, they will be entitled to receive the copy of the minutes. So they might come to the court and to get the copy, or ask the court to provide them with a copy of these minutes of witness examination.
Thank you. So I think we've established that in every jurisdiction it is indeed possible to ask the witness and subpoena the witness to appear, take this evidence and use it in arbitration. If we then turn to the second big portion of our case study, the documents that are held in each of the 4 jurisdictions. Starting from Tatiana, could you let us know, is it possible in general to request this party to produce documents that are held in its possession and control?
So the courts usually will not be ordering disclosure in support of arbitration. That is reserved to the tribunal. What the court can do is it can order a witness to produce certain specific documents. So you can make an application under Section 43 for summons to a witness, and it could be that that witness is summoned not to give evidence, or not just to give evidence, but also to produce documents. But what you have to be able to do is specify in your application exactly what documents you're seeking. Sometimes you can describe them by class, but usually in order to succeed, you need to explain what document it is that you want the witness to produce, because the court has to be very clear in the order what the witness has to do, and the witness has to be clear from the order what he has to do or she has to do. So you have to specify the document, and you have to explain to the court why you believe that this witness has that document. So that's one thing that you can do. Another thing that you can ask, and this is usually a third-party witness, the only thing the court can order the parties to do is make an order under Section 44 to preserve evidence. So if you're worried that a party, your opponent, might be destroying some documents, you can come to court and you can ask the court to make an order for preservation of evidence, preservation of documents. But the court will only make this order if the tribunal has no power to do this, or for the time being cannot act effectively. So that usually would be the case where the tribunal hasn't yet been constituted. But even then, there is a kind of interesting debate at the moment whether the availability of emergency arbitrators is in fact sufficient to make sure that this condition, that the tribunal is not able to act effectively, is not complied with. So there has been cases where the court held that availability of emergency arbitrator powers under the LCIA rules meant that the court has no jurisdiction to make any orders at all under Section 44. There was one case, though, quite recent in the commercial court, where the court said, well, I have evidence it will take about 11 days for emergency arbitrator to be appointed, and I really think that this order for preservation of documents is very urgent, so I'm going to make that order. So it all depends is the answer. And the more evidence you can provide as to why your case is urgent and why the court should be ordering you, giving you this order that you're asking, the better the better chance of success you will have.
Mm-hmm.
So
thank you. So, just to let you know that we started already receiving some questions. I suggest that we deal with them at the end because they already relate to the previous topic that we discussed, witnesses. So I suggest we proceed with documents and then have some round of questions from the audience at the end, covering all topics. So thank you, Tatiana, on the approach of UK courts. I would now like to ask Gabriel, so what is position in Switzerland, and is it possible to ask the court to order production of documents by a party in a situation where such documents are held by this party in different jurisdiction, not in Switzerland?
Thank you. I was actually pleased to see that finally I found some, let's say, similarities also with common law jurisdictions, Tatiana, because also in Switzerland, and this is also the case if you ask for witnesses to appear in front of court, you always have to show a necessity. You have to show that the arbitral tribunal is legally not in a position to do so. There is possible simply means really legally in a strict sense. The arbitral tribunal not gather that evidence itself, or whether already geographical distances or other impediments may be sufficient. When it now comes to the documents, yes, the short answer is yes, because the state court who can be asked for assistance in evidentiary proceedings can apply all means it would have in ordinary state court proceedings, and the order of for documents is also an available mean, and that means that it could do so. If a party in a tribunal, however, approach the court and they ask them to order a document, they have to show that such document is relevant and material, because the Swiss approach to document production is far more narrow than in the common law jurisdictions. So they will definitely check whether this is necessary. And that is, of course, even more strictly applied if you would ask the production of a document from a party who would not be in a possession of such document, which is, however, possible. What you would have to show is that that party, where the document is not in the jurisdiction, but what you would have to show is that the party actually is in possession of such document. That means that it is for the party not unduly burdensome to get hold of the document. So theoretically, you could ask from a party, a third party, to produce documents. If you show that the tribunal cannot do so, that such documents are material and necessary for the outcome of the arbitration, and that that party is in a possession, has access to, and that would even apply if that document would not be in the Swiss jurisdiction, but you can show that without undue burden, not too much efforts, etc., that party could produce that documents. You would have, the same applies if they have to appear as witnesses, you would have to reimburse them with reasonable means for any efforts and costs they would have, or the time they have to spend for producing these documents, or for appearing to court if they come as a witness. That's the answer.
That is very interesting. Thank you. And we now come to US, and the question to Remy is, can the court order production of documents not from a party, but from a third party?
Yes. And to answer also the question before, Section 1782 also requires the target of your document request to provide documents even if they're located outside of the jurisdictions. The requirement is only that the target, the witness, be found or reside within the jurisdiction of the court, but not the documents themselves. So that's the short answer. And yes, the process under Section 1782 allows a U.S. court to order discovery from any person or entity who resides again or is found within the court's jurisdiction, regardless of whether or not that person is a party to the arbitration or a party to the arbitration agreement. But there is a caveat, and that is that the notion of residing or being found within the court's jurisdiction is one that has been interpreted slightly differently by different courts in different circuits in the US. And so, for example, there is, I believe, in the Fifth Circuit, which includes, in particular, Texas and Louisiana and Mississippi, there is case law that suggests that for a company to be found or in that jurisdiction, it's enough for the company to have some sort of office. There's case law that suggests that. Now, in the Second Circuit, by contrast, which is important because it includes New York, in the Second Circuit, I think there's some recent case law from 2019 that suggests that for a company to be found or to reside within the court's jurisdiction, it needs to either be registered locally or it needs to have its main place of business locally, or if not, it needs to have minimum contacts with the jurisdiction, but these minimum contacts need somehow to be connected to the evidence that you're seeking. So it suggests that a Ukrainian company that would have a small office in New York with limited activities and which activities would be unconnected with the evidence that you're seeking to obtain, that might possibly not be enough in some parts of the US, at least in the Second Circuit. That's my understanding. But the short answer is yes, you can get documents regardless of where they're located, and yes, you can get them from individuals and companies that are not parties to an arbitration or to an arbitration agreement.
Thank you. And is it any different in other jurisdictions, Ukraine, UK, and Switzerland, the position in respect of third parties?
No, also we also can get documents in possession of third parties. And let me also add a practical point of view. This is going to be the practical relevant question, if you can do that. Because if you ask documents from the party, the tribunal will hardly ever allow and not itself resort to complex state court assistance proceedings with foreign state courts, because it has additional means itself, drawing negative interferences, etc., if a party would not produce the documents. So the practical relevance is truly in making sure a third party could be coerced to produce documents.
From the Ukrainian position,
Irina, please.
generally that it is possible to request the court to product the documents from a third party. But in practice, the burden of proof is very high. So you need to prove that, first of all, these documents that the third party owns is really very important for the case. It is impossible to continue the hearing. And of course, here you could face certain complications because the case is under consideration in arbitration, and you are making the request at the Ukrainian court that is not familiar with the substance of the dispute. So theoretically, it is possible to make such application, but in practice, you should persuade the court that it is necessary to compel the third party to produce the documents or evidence in support of arbitration.
So
Thank you,
in the
Tatiana.
UK, there's actually been a recent decision in 2020 by the Commercial Court, and then it was reviewed by the Court of Appeal, which said that Section 44 powers, which effectively the powers to take a deposition and to order preservation of evidence, can only be applied to the parties to the arbitration. So when you're asking for preservation of evidence, it looks like you can only apply for an order against a party to the arbitration. Now, it might be that this case will be reviewed because the Commercial Court said the entire Section 44 is limited to parties to arbitration. The Court of Appeal actually disagreed and said that the section dealing with the taking of evidence can apply to non-parties because it refers to witnesses. And a witness must mean more than just a party to the arbitration. Witnesses must include third parties. But the Court of Appeal thought that the rest of the section would only apply to parties to arbitration. So I think that particular issue is still up for grabs because actually that case really only dealt with the taking of evidence. and not with the issue of preservation of documents. So the comment by the Court of Appeal is strictly obiter and not binding, but that's the law as it stands at the moment. But of course, where you are getting witness summons for the witness to come and give evidence and or provide documents, that can be that order can be obtained against the non-party.
Thank you, Tatiana. And now question to Irina of a more general nature. Are there actually many cases in your jurisdiction in Ukraine dealing with this request to the courts to obtain this support? And have you dealt with any of them yourself?
So I will start from the second question. So in our experience, we have never made application to our court in support of arbitration. The reason why we did not pursue this measure is that because we did not have such necessity. Because usually we have different alternative methods to collect the documents, like advocacy requests that we can send and use in Ukraine in order to collect necessary evidence. But of course, in case we would understand that there is no other option to examine the witness and to collect the evidence, so we will try it. And concerning the number of applications, I think that in reality there are few. And the reason is that we do not have a very well drafted law that provide the detailed description how the applications should be made, how it should be considered by the court, what is the timing of the court to consider such application. And in practice, the parties sometimes do not want to make such application because they understand that it would only delay arbitration proceeding, because there are no time limits for Ukrainian court to consider such application. And usually the parties elect different ways to collect the evidence. In practice, there are some cases where the parties tried to make some application, but it was made more in order to delay the proceeding or to use some kind of guerrilla tactics. So generally, our law, of course, need to be modernized and need to be amendment in order to provide a more effective procedure to make such application and collect evidence or examine the witness.
Thank you, Irina. And actually, based on your answer, I think maybe a very important question to all the participants. Is it really efficient way to gather evidence? Is it something that you would recommend a client to pursue in real life arbitration with strict deadlines?
Can I go first,
So, please.
Alexander? Thank you.
Sure.
I think generally, sometimes when you have an uncooperative third party, making an application to court would be the only way you can obtain documents or evidence from that third party. So if you are dead set that this particular person or company has the evidence and you need that evidence, and that might be the only way. How long will it take in the English court? Actually, because these applications tend to be incredibly focused, I would only recommend making them if you're absolutely sure what documents it is that you need and that the party in question holds them. So, for example, it might be company accounts or something like that, or company banking details, banking records, what payments they've made. So that's the kind of thing that I'd normally apply for. You can make the application to court, and the court can actually be very quick to resolve that application. It's a fairly simple application. In the English commercial court, we have the Friday applications list. As long as your application is less than half a day, you'll be in the Friday applications list, and the court will usually make a decision there and then. So you're in court, you make your application, and the court gives you the ruling, and you get your order the next day or as soon as you can draft it. And so then it is up to you what you do with that order. Whether or not that order is of any use is another question. So how long then it will take you to enforce that order, that's another thing for you to consider. And another thing to think about is if the court refuses then you think, well, is it worth going on appeal? Because of course, any appeal will take some time. Going to the Court of Appeal, we don't have any deadlines for judges to produce judgments. That it's just as a matter of practice, I can say that if your application is short, you will get your order on the day you make the application. When you get to appeal, the Court of Appeal, it operates how it likes to operate. If your matter is really quite urgent, so you're talking about somebody possibly destroying evidence, then you can ask for the Court of Appeal to hear it urgently, and they will accommodate you. I mean, I've had a hearing in the Court of Appeal at 6 o'clock in the morning because our application was that urgent. So you can get swift justice in the UK courts, but if there is no urgency, then I'd probably say it might not be worth it if you're going to appeal.
Can I
Thank you,
also
Gabriel.
quickly step in? Yeah, Alexander. I think I would say my over 20 years of experience, I have only 2 cases where I could see that such resorts to state courts have been used, and it's really very rare. In Switzerland, I cannot give you a statistics because the law for arbitration seated abroad is totally new, and also before they did not distinguish between judicial assistance proceedings or the Hague Convention in the statistics published and truly direct support requests by arbitral tribunals seated in Switzerland. But my short answer, or try to be as short as possible, is as follows. I think for witnesses, I would really think 3 times before I would ask and go for this burdensome and still time-consuming proceedings, because we all know in many jurisdictions and also in Switzerland, it will simply be that the list of questions will be submitted, and then the judge may just simply read out. So if I would go for such state court assistance, and I'm glad that it exists, then it is exactly for, like Tatjana has now pointed out, it's very limited cases where you really know such documents exist. The parties to the proceedings really are not in possession of these documents, and these documents are absolutely crucial for your arbitration proceedings. I think then it may be worth, because we all must understand it will lead to a suspension of the arbitration proceedings. It will take time, although now in Switzerland I'm very positive that it will take much less time, as you can directly go apply to the judge can directly apply its own law, etc. But it will take time. And so you must have really compelling reasons to do so.
Thank you. And Remy, what about US?
Yes, I think Section 1782 can be a game changer in many international disputes if it's available to you. And that could be a big if when you're talking of a commercial arbitration, like we said. But if it's available, it could really be a game changer, because as I mentioned before, you can make your 1782 application before your arbitration is started, such that the timing would work potentially nicely with the arbitration. Second, because when you're seeking information from certain very large companies that are often on the receiving end of 1782 applications, they have a process in a place. They have lawyers that are used to dealing with these applications, and often sometimes you can negotiate a scope of testimony or documents and get that without having to necessarily litigate it. And so it could be done relatively cheaply and relatively quickly. I mean, it can take as long as, I understand, as a year and a half if you have appeals, etc. But it could also take just a few weeks potentially. So it could really be a game changer in a number of situations. For example, if you have a company that has a case that relies on showing that certain emails were sent fraudulently, because the emails were sent not by the owner of the email account but by somebody else on their behalf, you could potentially do a Section 72 application against a company based in the US that manages or runs, if you want, the email service. There's some statutes that would prevent you from getting access to the substance of the emails, but you could not. Normally, you should be able to have access to metadata, including the location of the person, maybe the IP address of the person that sent the allegedly fraudulent email. And so that's a practical example of a case where you could really have a game changer. You could win or lose your case because of that. And the final point is that it could also help with the settlement negotiations. If you get access good early on, it could potentially help you resolve the dispute before you have to go through the entire arbitration. So on balance, I think it's a great tool, and we look forward to hearing from the Supreme Court later this year as to whether or not this is available for private arbitrations.
Alexander, allow me just one caveat. Remy, I have been quite involved in a few arbitration where we also actively as counsel or where I was acting as an arbitrator was confronted with evidence that was gained through the 1782 proceedings. And as I have stated before, the big caveat I want to repeat again is you must make sure that you can actually use this evidence later on in the arbitrations, because I see a lot of arbitrators who are very reluctant then to allow such evidence to be submitted, because they say normally in our proceedings you would not have had the possibility to gather this evidence. And you will see, of course, also opposing parties heavily opposing. So as an arbitrator, I was every time totally challenged when I had to decide whether to admit such evidence gained. And as a counsel, I always had to advise the clients, let's go for it. It costs something, and I cannot even assure you whether we later can use it. But where I agree with you, Remy, it is a very interesting tool for settlement discussions, because the other party faces this uncertainty as well, and if they know you have this compelling evidence in your hands, it may move them. That's correct.
And it's a very good point, Gabrielle. I agree with you. So a few months ago, I was at a meeting of the International Arbitration Club of New York, and we did a vote of the members on whether or not members thought that Section 1782 should be available to private arbitration. And I was surprised to see that it was fairly evenly split. I think it was something like 55% in favor, 45% against. And the thinking of people who were against the idea of using 1782 in support of foreign private commercial arbitration proceedings was precisely that you could argue that the parties, when they agreed to insert an arbitration agreement in their contracts, at least US parties, part of the reasoning was probably that they wanted to get out of the US court discovery system in the first place. So the fact that your discovery would not be available necessarily in arbitration, shouldn't it mean that the US court should not grant it? So that's, I think that's a very fair point, and it's one that's debated.
Many thanks to all the participants. These are very valid and reasonable considerations that each party should take into account before considering whether to actually use it or not. Unfortunately, we ran slightly more than planned. Therefore, we will not be able to have the second poll, but I imagine that it may have changed a bit, but overall, on balance, probably it is still something that is useful and the audience will support it. So we had one question, but probably we will not look into it. The question was which rules or procedure the court will use, whether its own or of the seat of arbitration. I think we covered it in all of the jurisdiction that the court will use its own rules of procedure. So with that, I thank all of the panelists. I think it was very entertaining and helpful discussion to really understand how this process works in all the jurisdictions. So many thanks to all of you. And I think we'll be now switching to the next panel.
Thank you also to you for being an excellent moderator and for this interesting session. Thank you.